We are on the record in the Lovelady matter, case D19-593-140D. Starting with plaintiff's side, please confirm your appearances.
Good morning, Judge. Audrey Beeson, bar number 10519 on behalf of Jessica Lovelady.
Good morning, and I do see the plaintiff present. Now moving to defendant's side, please confirm
Good morning,
your
Your Honor.
appearances.
Louis Schneider, 9683, from Michael Lovelady. He's present here in my office, Your Honor.
Good morning, and I do see the defendant present. And we also have Ms. Hauser, who was appointed as the guardian ad litem. Ms. Hauser, if you could go ahead and confirm your appearance.
Good morning, Your Honor. Michelle Hauser, bar number 7738, guardian ad litem for the minor child.
Good morning. Okay, this is the
Your
time.
Honor.
This is the time set for trial. I also scheduled the order to show cause at the same time, and there are papers, a motion that's been filed and set for today. So let me start by asking: are there any stipulations or agreements before we proceed?
No, Your Honor.
Okay. I've had a chance to read the papers. I want most of our time to be spent in receiving evidence and hearing testimony from witnesses. With respect to the motions, and I'm ready, I've had a chance to review the papers. I don't need any discussion. I'm prepared to rule on the underlying papers, including the motion that was set on an OST. At this point, and given the history of this case and the court's prior hearings, I'm denying the motion to allow Mr. Ponzo to testify as an expert witness at trial. I don't need to go down that path. Originally, it was the court's understanding that his role was different in nature in terms of a reunification specialist. That being said, I'm denying the counter motion to strike his report. The court viewing that again as reunification, or to have Ms. Beeson testify as a witness. I'm also denying the request to have the minor child testify by alternative means at today's hearing. Certainly, I would invite Ms. Hauser's participation, and she's present in the hearing today as Abby's guardian ad litem. That's the extent to which I'll receive information as it relates to the child and any other competent evidence that may be offered at the time of trial. But at this late juncture, I'm not inclined to have additional witnesses appear and testify. So I'm prepared to hear from the parties as witnesses. I anticipate I'll to the extent that Ms. Hauser's had an opportunity to meet with the minor child and may offer some insight in that regard, I'm certainly welcome to entertain that input and any other witnesses that have been properly designated. So my preference is to take advantage of the time we have together to receive as much information as possible to make final determinations at this time. So those are my rulings as it relates to the motions that are before the court. Again, this was scheduled for the full day, so each side is entitled to half the time that we spend here today. You can use part of that time to make an opening statement, or defer any argument time to closing arguments to the extent time is remaining. So I'll start with the plaintiff's side. Ms. Beeson, do you desire to use any of your time for an opening statement?
No, Judge, I do not.
Okay, Mr. Schneider, do you desire to use any of your time to make an opening statement?
No, Your Honor, but I think the court needs to be made aware that because we didn't appoint Ms. Hauser until November 4th, and then it took a couple of weeks to get a representation agreement and retainers sent over, she's not had an opportunity to meet with the minor child. So she's got someplace else she needs to be. I don't know that she has anything to add. You can certainly ask her, but I just don't think that Ms. Hauser has had a chance to represent I don't think she's even met with Abby. In fact, I know she hasn't.
Okay. And Ms. Hauser, if you can just, that's what I'm getting that sense from what I'm hearing and seeing, which I understand, and there may be a need for the court. I anticipate I may be setting additional proceedings because there was that stipulation to have Ms. Hauser appointed for that purpose. So I'm not closing the door in that regard. I want to be clear about that. So that may be helpful for the court down the road. And I'm not presuming as I indicated at the outset, that Ms. Hauser has even had a chance to meet with the child, and I'm getting the sense that she hasn't. So.
No, Your Honor. I was retained 2 weeks ago today, so
Okay.
the Thursday before Thanksgiving. So obviously with Thanksgiving, that was a delay. And then Monday I was in a full day trial with Judge Marquis as a guardian ad litem. And I've reached out to counsel, but there's no order that prescribes my scope. So like in guardian ad litems in front of Judge Marquis, we have a specific order under Rule 8 of what we're allowed to do, which is often different than in the D cases. And I don't have a clear understanding from counsel or this court what they expect. So it's kind of, I don't have a starting point, I guess is what I'm trying to say. So if counsel could agree, do they want me to do a 125C? Do they want me to record any conversations with the minor child, which is not normal because it's not in lieu of testimony under 16.215? Do they want me to do collaterals? Exactly what am I doing would be a great help to me.
And that makes sense.
And I do have Ponzo's report. Your law clerk was kind enough to provide that to me. I spoke briefly, maybe 45 seconds to Mr. Ponzo, only because I have him in Judge Marquis as a guardian ad litem. In that case, he was assigned as a reunification therapist. So he said, hey, I heard you're on another case, and we have a few cases where I'm the JAL. But nothing of relevance, just for complete disclosure, given the allegations raised in this case. I just thought everybody should know that.
Okay. Well, I think that is an important discussion to have and talk about perhaps how that ties into how we proceed today. I'm fine and prepared to receive testimony today, but I think that may be important information to obtain. As far as, and I think it was the defendant's original proposal to have a guardian ad litem appointed, so and I'm not necessarily here to confine the scope of the guardian ad litem, but Mr. Schneider, what's your position in terms of her scope and what parameters and protocols we implement?
Well, Your Honor, I guess I need a little clarification from the court. You said that you don't want the minor child to testify by alternative means, but she is on my witness list, Judge. But if you're going to exclude Abby from testifying at all, I would like then Michelle Hauser to be able to have an opportunity to speak with her, because it's a critical. I understand not wanting to involve children. I really do. But I have no choice. And the new rules define a child as anybody under the age of 14. Well, Abby's almost 15. She'll be 15 in 4 months. But if the court is inclined not to have Abby testify, and I need that clarification, then I absolutely need to have Michelle Hauser meet with Abby, read the original report by Keisha Weiford that I have not sent to Michelle Hauser, because I didn't want to have communication outside the scope of the court, because the court had never defined what Ms. Hauser's scope of her involvement is. So I hate to do this, Judge, but I think that Michelle's a critical component to this, and if you're not going to let me put Abby on, we need to continue this so that Michelle can do a proper interview and report for Abby's wishes. Because Abby, as I said, she's almost 15 years old, unless the court's going to let her testify today, and it'd be my preference not to do that, but I feel like I have no choice.
All right, Ms. Beeson?
Judge, and I appreciate what Mr. Schneider's saying, but Ms. Hauser did reach out to us, and I did answer all of the questions, including Mr. Schneider, and Mr. Schneider has not responded to any of the emails. She specifically asked for counsel to agree to the scope. She's asked those questions. I've responded to all of them. I've agreed that she should have access to the child interview as well as Ponzo's reports. I've agreed that she should have access to the child, to the parents. I don't think it's fair to my client that Mr. Lovelady waited approximately 9 or 10 days before even reaching out to Ms. Hauser from the last court date, and that Mr. Schneider's had no communication to help Ms. Hauser guide her so that she could even start the process before today. I did reach out to Mr. Schneider and ask if he would be willing to at least do the finances and the order show cause today, with the understanding that we would probably need a day 2 for custody to allow Ms. Hauser time to do her job, but he did not respond.
Okay, what's your position in that regard, Mr. Schneider, to take care of the show cause and the financial issues today and perhaps defer this for some time? I'm hearing from both sides that to the extent that we need more information perhaps from the child, and my preference would be that it would be through a guardian ad litem, through Ms. Hauser, as opposed to
Your Honor,
calling Abby in as a witness. I just, if I went down that path and said, okay, let's call Abby as a witness today, mark December 2nd on your calendar as a day that Abby will never forget for the rest of her life, as being held into court. And I'd rather not do that to this young lady. So
I understand.
So, is there an appetite to go down that path and allow Ms. Hauser to perform her function as a guardian ad litem? And
That would be my preference, Your Honor, but in all candor to the court, Ms. Beeson feels that she just jumps in on everything, and I got an email from Michelle Hauser, and properly so. She said, I'm not going to do anything until I get some designation from the court as to what my role is in this matter. I didn't think it was going to help if I jumped in and started telling her what her role is, because I'm not the judge in this matter. Michelle does a fine job. She's extremely ethical. It would absolutely, I couldn't agree with you more about not wanting to put Abby on because I need Michelle's testimony. So, Your Honor, please allow Michelle to do her job, to meet with Abby, and then I'd like the court to order that both counsel are not to interfere with Michelle Hauser or try to sway her testimony in any way.
okay, well, yeah, and I don't anticipate that's going to happen. But I don't have a problem making that as an order of the court. It's not something that I foresee happening. But I do agree that I think we need Ms. Hauser she needs the opportunity. First of all, we do need to define her role. If it also includes limitation on contact by counsel, I'm fine with that. I want Ms. Hauser to have the freedom to do exactly what she needs to do. As far as those parameters are concerned, and I know at times it's different in the guardianship arena, but are there standard forms that you rely on, Ms. Hauser, in that regard that defines your role?
In the guardianship arena, yes, because we're compelled to follow Rule 8. From department to department, in non-guardianship cases, the judges all have a very different spectrum from I'm not a witness, so I don't testify, but I can cross-examine, to I represent the child but not do a best interest. So there's no, unfortunately, consistency through the D, quote-unquote D cases of how the scope is.
Okay.
And that's why I wanted to get, confirmation. For example, Rule 8 in the guardianship rules says I can't talk to the litigants when they're represented by counsel, absent consent of counsel, and whether or not counsel wants to be present during any contact with their clients. So because there's no uniformity in the D cases, it kind of always starts off in the little tricky area.
Okay.
Your Honor, I will absolutely stipulate that Michelle Hauser can talk to anybody she feels is relevant in this matter, and without counsel being present. I'm prepared to stipulate to that as long as Ms. Beeson does.
Ms. Beeson, are you prepared to stipulate in that regard as well?
Yes, I am.
Okay. All right.
Your Honor, while we're defining Michelle Hauser's role, I'd also like to make sure, and Michelle, I don't mean to offend you, but I want to make sure we do an analysis on the best interest of the child when she does her report. And I see you're nodding in agreement.
Well,
So
I
I'd
would
like that to be
expect,
more.
let me know if either party has an objection. I would expect that the guardian ad litem, Ms. Hauser, would be viewing the factors under 125C.0035 as part of her function as the guardian ad litem in making determinations regarding the best interest of the child. Is there any objection to that?
No objection.
And Your Honor, I see Mr. Ponzo has logged into the case, and since he's not going to be a witness, I'd ask the court to exclude him.
Right. Good morning.
I'm sorry, I was.
Good morning, Mr. Ponzo, and welcome. Good to see you.
Good morning. I got a message that said I should log on, but I'm happy to get off and wait.
Yeah, and it doesn't look like, given where we're at from a posture standpoint, I don't know that we'll need you today. So I'd go ahead and excuse you from appearing today.
Okay.
Okay. All right.
Your Honor, as far as going forward on this matter, I've spoken to my client about the assets of this case, and he understands that it's a matter of law. There's not much to argue about in terms of assets and quadros and so forth. I'm confident that we should probably concentrate our time on custody. And since we're going to defer on that, Ms. Beeson and I could probably resolve the assets in short order. I mean, that's by operation of law. There's really no gray area on that. This, as far as I'm concerned, this whole case is only about custody and the minor child.
Well, I do want to get into that discussion, but before we go down that path, because I want to allow Ms. Hauser to get going with whatever she probably has other commitments and obligations today. So let's iron out Ms. Hauser's role and define that, and then we can have a separate discussion about assets. You may be right. I want to hear from Ms. Beeson in that regard. Most of our hearings have been consumed with issues pertaining to custody. Contempt is still an issue that's before the court as well. So as far as her scope, I know, Ms. Hauser, you mentioned your role as perhaps an attorney that asks questions, or are you going to be called as a witness? Do we have a consensus in that regard?
Your Honor, I would leave that up to Michelle Hauser. I really think she knows what she's doing. She's been doing this for a long time. She's acted in this role. So, and as far as the contempt as well, I think that Michelle can cover that with the child as well. I mean, is dad preventing Abby from seeing mom? So I think that a lot of information can be garnered from Michelle doing her job, and however she wants to do that, whether she wants to testify or just submit a report, I would leave that up to Michelle Hauser.
Ms. Beeson?
So Your Honor knows, because there's always confusion. The D cases, sometimes the judges are pointing the attorneys like similar to a cap attorney, where we don't look at best interest. Given what the litigants have said, I wouldn't represent the child. I'd represent the best interest, which is more, I guess, in the abuse neglect world, akin to now I can't remember the name. Not a cap attorney, but the Ms. Beeson. I know you're there every day.
It's a CASA.
Thank you, Ms. Beeson. So it'd be more as a CASA, and in that role, I normally I do either testify or, for example, in guardianship as a best interest, I am an attorney advocating the best interest. So then, like Monday, I cross-examined all the witnesses, made an opening argument, did that type of thing. So it's really up to how this court wants me to do it, because I've seen it done both ways in the D case. I just need to know, am I testifying versus am I doing questioning? Because obviously that's two different,
Right.
totally two different roles.
You're either a witness or you're an advocate for the child's best interest.
Yep.
Quite frankly, I'm looking at it from the standpoint that you're an advocate for the child's best interest.
Okay, so then I wouldn't be testifying. I'd be asking questions and preparing a report based on the best
Correct.
interest with the ability.
Correct.
Okay.
Correct. Let me
Good
know
note.
if either side has an objection to that, but that's how I view Ms. Hauser's role as the guardian ad litem.
Your Honor, I guess I would like to, if I could, have the opportunity to call Michelle as a witness. I'm sorry, Ms. Hauser as a witness, but I will leave that up to the discretion of the court.
Okay.
It's really up to Your Honor, because it's done both ways.
I'm inclined, as I indicated before, that as a guardian ad litem, you're an advocate regarding the child's best interest. So that's how I would approach it. Other parameters that we need to discuss, Ms. Hauser, to help define your involvement and role?
Under NRCP 16.215, I don't record any communications with the minor child, because I'm not, as a best interest analysis, I'm not taking it as testimony.
Right.
I'm taking it as a factor and balancing and weighing. So I do not record. I do know attorneys in the past have been upset that these interviews are recorded. It's really up to the court, but it's not in lieu of testimony. So.
Well, unless there's some strong feelings I hear from either counsel, I would not be inclined to require that.
No,
Your Honor,
Judge, I
I'll leave
don't.
that up to Michelle. I'm sorry. Go ahead, Audrey.
I would not request that they be recorded.
And I certainly don't see any need to record conversations, Judge.
Okay, fair enough.
All right, then I think the only other thing is if the litigants, I mean, I've looked at the file because it's not a sealed case online. So I kind of read some things, but nothing in depth. So if there's any specific documents or any items or third parties that the litigants would like me to interview, it would be helpful if they could email me maybe by, honestly, by Tuesday, Wednesday of next week, only because, well, I'm in Idaho. Everybody here knows this. But I'll be back Saturday, unless I get snowed in somewhere on the drive back.
Okay.
But I'll be back Saturday. I'm driving.
Fair enough.
With my mom and 5 boxes of Christmas decor and 3 dogs. It'll be
All right.
fun.
Fair enough.
If anybody wants to come and drive my mom and her Christmas decor back, please
Yes,
volunteer.
If I had my choice, I'd stay where you're at. All right. Before we let you go, we probably ought to talk about a date with everyone here just to make sure there aren't any conflicts with the calendar. How far out would you want the custody aspect to be set?
For me, it's 30 days is usually customary, 30 to 45 days. So it's really up to how the parties get me the information and everybody's availability. So if we could, 30, 45 days, I'm fine with that. And then I'll issue a written report. I normally file that confidentially, and then if the trial goes forward, then I can question witnesses based off that written report.
Well, we are heading into the holidays. Counsel, what, Ms. Beeson and Mr. Schneider, schedule-wise, what are you looking
Your
at?
Honor, I'm fine on, I think, given the holidays and so forth, I think probably 60 days is probably more realistic. But I'll submit to the court's discretion on that as well.
Judge, I don't want to push this out another 60 days, especially in light of the fact that my client has not had the child since September.
Custody.
So I would be comfortable with the 30 to 45.
Are we looking at a full day? Or a half day?
I would say in an abundance of caution, a full day.
And I was about to say a half day, Judge. So, again, I think Michelle's report is going to be very telling and probably decisive. So I think a half day, but again, I wouldn't object to a whole day. I'm not sure what we would do for a whole day, but okay.
Looking at January 14th at 9 a.m.
I'm good with that, assuming you'll still be the judge on this case.
I will be. I am one of the few that will not be losing any cases. I will be gaining cases.
Really?
Well, I will no longer be the presiding judge, so I currently operate.
You have to give, but you have to give my business partner, and that's why I have to come back from my lovely Idaho cases. Preferably all your nasty ones. Feel free.
I wish that were the case, but unfortunately, I am only increasing my caseload, not decreasing.
Okay. Yeah, I'm fine for January 14th.
January 14th works for me as well, Your Honor.
For me as well, Judge.
Okay, January 14th at 9 a.m. That'll be the custody aspect. Okay.
Thank you all.
All right, and we will have an order prepared from today. I don't have a problem, Ms. Hauser, if you want to prepare the order that defines your scope, if you're comfortable doing that, you may submit that, have that circulated to Mr. Schneider and Ms. Beeson for review and signature, and then submit that.
Yeah,
to the court.
I probably have the templates. If the council
Okay.
doesn't mind, I can prepare that fairly quickly.
Okay. All right.
Is that all right with
appreciate
council?
that.
Of course, Michelle.
Yeah.
All right.
Okay.
Thank you guys. I'm going to go to my advanced CLE. I hear Mr. Shapiro has some funny jokes that nobody's finding funny, so I'd like to know it's not funny.
Okay. All right. Thanks for your appearance.
Thank you. Bye-bye.
Thanks, Michelle.
Okay, so let me just follow up. As it relates to, well, let's start with the asset and debt issue. I know Mr. Schneider made comments about perhaps that might be the easiest those might be the easiest issues to resolve. Ms. Beeson, are there issues in dispute that we need to have some discussion and receive some testimony on?
Well, here's the problem, Judge. We need to know when the community ends. Without knowing when the community ends, I don't know that we can take values
That's a fair
and,
point.
Today. Also, while Mr. Lovelady has filed an updated financial disclosure form, he did not update his 16.2 disclosures. So I don't even have the documentation to support his financial disclosure form. And I didn't know how the judge would how you would want to deal with that either. So there's quite a few concerns that I have about the division of assets and debts.
Well, let me just offer a few comments, and perhaps we can get into some detailed discussion. Part of it does hinge on how we define the termination of the marriage, because as both counsel likely are aware, well, I'm sure you're aware, and this court is keenly aware of the decision in Shofi Kogod. That does not occur until there's basically a written decree that's signed by me and filed with the clerk of the court. The marriage is still ongoing. That becomes an issue, recognizing that custody is not going to be tried until next month, and recognizing the fact that the court is not allowed to bifurcate these proceedings with absent a stipulation by the parties. And I'm not here to state that you need to stipulate to that regard. I guess that's my question, however. Do these parties want to be divorced forthwith with a written decree issue? But that's something I can only do by stipulation. Is there a feeling?
Both parties are yes, so I imagine that is a yes.
A yes, okay.
I'm sorry, Audrey, are you agreeing that we're going to bifurcate?
Yes.
Yes, Your Honor. My client would like to be divorced today, and given the fact that we're just doing the asset portion, which is the easy portion, we're prepared to stipulate to the appraisal and so forth and so on, and quadros. I mean, I've explained to my client at length that this is all by operation of law. There's really no gray area unless Audrey has some. I mean, Audrey, if you can point out any gray areas that you think you want to resolve today, I think we can probably get this done in short order.
Well, let me just recognize, for purposes of the record, under GOJAC, both parties have stipulated to bifurcate the proceedings. So I do intend to pronounce the parties divorced today. I understand that the written decree still needs to be prepared, but I anticipate that'll be prepared in short order, and I'll take volunteers to prepare that on either side. But so that assists basically in determining how we proceed as it relates to the division of assets and debts. It's my understanding that the defendant appears to be an employee of the city of Henderson, so I understand there are PERS benefits that are going to be attached to that. That would be a simple application of the time rule formula under Gammon-Fondy, and the court would retain jurisdiction for the purposes of entering qualified orders for the purpose of dividing that asset. It's my understanding plaintiff is a facilities manager at Park MGM, so I don't know that there is a defined benefit retirement plan. There might be defined contribution plans. Is that the case, Ms. Beeson, for the plaintiff?
Yes, she did stop contributing at one point in time, but there is a pension out there that has been disclosed, so that will need to be divided as well pursuant to the time.
Okay, and so we would use today's date for purposes of that division. As far as other assets, recognizing we're using basically today's date as the line of demarcation, pending the signing off on a decree. Other assets that we need to have that discussion about and further information on.
Your Honor, there's a deferred. I'm sorry. Go ahead.
While we can certainly delineate what the division would be, I don't know that we'll be able to agree to a community property equalization payment just because we haven't been able to in the past. So I don't know if Your Honor would want to set aside the first hour at the next trial in case we can't agree to the community property equalization payment, even if we can agree to and the values are what they are. Documentation does need to be exchanged, and then the parties would reserve the right. And again, I mentioned that because we see that Mr. Lovelady has purchased a new vehicle. I don't know what funds were used or if that was put on a community credit card. So there might be some issues like that, just because, again, I don't have the information. Mr. Schneider, what are your thoughts?
Audrey's correct. He was in a car accident. He hit the back of something, I forgot, and he totaled his car, so he had to get a new car. We'll get all of that information to Audrey, as well as, I agree with Audrey. We can come up with all of the parts of the assets and an equalization payment if we disagree on that. I agree that we could just allow the court an hour on that day to decide how you're going to divide it up. But I'm confident, Judge. Again, it's by operational law. That's the only thing that's black and white in this case. This should be the easy part, and I'm sure we can get that done, Your Honor.
Okay, I accept that. Listen, I'm fine with that. So I'll task counsel to basically start crunching those numbers, exchanging information. That would be my order. You exchange information to ascertain what the values are, and then we can spend some time, perhaps the first part of the proceeding in January, to talk about any final numbers. If there's a disagreement in numbers, I just need to be informed what we're dealing with. So I'll task counsel to do that. But in the meantime, I think we should have a decree prepared recognizing the parties have stipulated to the divorce. Any volunteers to prepare the decree of divorce?
Judge, I can prepare that.
Okay, if you'll prepare and submit to Mr. Schneider for review and signature. I don't have a problem. If you want to include, we don't have to, if you want to include the division of the retirement plans as part of that decree, or if you'd rather defer that to all of the property, I'm fine either way. I don't think the retirement plans are going to be impacted by the numbers that you're talking about.
I don't think they will. Well, there might be because of the 401k,
Okay,
right, Mr.
that's
Schneider?
true.
Right, I agree with what Audrey's
Okay.
saying, Judge, but we're going to want to probably do some horse trading between the retirement plans and this.
And that's fair.
There's a big chunk.
That's
There's a big chunk.
That's fair. That's fair. So I'll just look to receive a decree of divorce that divorces the parties, and that at least establishes our line of demarcation. So, all right. So that takes care of that issue. So the only other the item that's before the court from our prior proceedings relates to the order to show cause. And I know, Mr. Schneider, you had mentioned having some input from Ms. Hauser as it relates to the issue of contempt. I'm prepared to proceed today. Ms. Beeson, what's your position in that regard?
Honestly, Judge, I'm not sure how Ms. Hauser's input would affect the order to show cause, so I'm prepared to proceed on that issue today.
Okay.
Your Honor, since I was planning on calling Abby, I mean, if my client's going to be held in contempt, I think that we need to have some input from Abby as to why she did not go with her mother, and whether or not her father encouraged her to go or discouraged her to go, and all of that would come out. And in fact, I think that should be part of Michelle Hauser's scope, and I think the court can give that the weight that you want. But I can't put Abby on the stand. I can't elicit testimony from her. I would really like to wait on that until our January 14th date, and I'd like you to charge Ms. Hauser with the questioning that type of stuff. And I think that would weigh heavy on the court's position.
Well, here's what I'm inclined to do. I do want to proceed with some testimony and evidence as it relates to contempt today. At the conclusion of the proceedings, I understand your point, Mr. Schneider, as to whether or not that becomes a part of the defendant's cause for the violation of the court's orders. I'll make a determination at the conclusion of our proceedings today as to whether or not I find there's additional information that might be helpful, or I can defer ruling on the issue of contempt. But I want to get as much information as I can today as it relates to the issue of contempt. There was a prima facie showing by the plaintiff that caused the court to issue the order to show cause, and so I do want to receive some testimony in that regard. Ms. Beeson, as it was your motion for the issuance of the order to show cause, it's not uncommon that I have that party lay the prima facie case for the contempt, And then the party that is alleged to have committed the contempt would be his burden at that point to show cause. So you may proceed with establishing that based on the fact that it was your motion.
Thank you, Judge. So then I would call my client first.
Okay. All right, ma'am, if you'll please raise your right hand to be sworn.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state and spell your name for the record.
Jessica Joy Lovelady, Jessica Joy Lovelady.
What's the middle name one more time?
Joy, Joy.
Thank you.
Okay, Judge, also to expedite things, because Mr. Schneider and I were not able to agree on the admission of exhibits, I would ask that the court to take judicial notice of Plaintiff's Exhibit 39, which is the JPI filed on July 23rd, 2019. Plaintiff's Exhibit 40, which is the order from September 23rd, 2019 hearing filed on October 23rd, 2019. Plaintiff's Exhibit 47, which is the order from October 13th, 2020 hearing filed on November 3rd, 2020. And Plaintiff's Exhibit 49, which is the stipulation and order regarding the mutual behavior order filed September 27th, 2020.
What's the middle one again?
Your Honor, most of those documents are court documents that have already been admitted. They don't need to be admitted.
Well, and Ms. Beeson's asking the court simply to take judicial notice. I think, I want to make sure I have the numbers right. 39, 40, 47, and 49.
Correct.
I will take judicial notice. Those are part of the court record. I will admit those, notwithstanding the fact that I am taking judicial notice. I am admitting those into the record for today's proceeding.
Thank you. Ms. Lovelady, what is the, and Mr. Schneider, I'm assuming because we're not doing the entire background that you'll allow me some latitude as far as laying foundation, correct?
Yes, of course.
Ms. Lovelady, what is the current court order pertaining to physical custody of Abby?
Physical custody is joint. We're on the 223 schedule.
Okay. And can you explain which is the two, who has the 223?
Yes, I have Monday, Tuesday. Michael has Wednesday, Thursday, and then the weekends alternate.
Okay. And when are the exchange times?
During school days, it's supposed to be after school. Since they're in virtual school, we just stick at a 3 o'clock. I said virtual school, sorry. We stick to a 3 o'clock pickup. And then on days when there is no school, it's supposed to be 9 a.m., but both Mike and Abby like to sleep in, so I usually pick her up around 10 or 11.
And that's by mutual agreement, correct?
That's by mutual agreement. I understand people like to sleep in. I'm not one of those people, but I understand it.
Does the court order contain teenage discretion for Abby's custodial time?
It does not.
Does the court order contain a right of first refusal if either parent is unavailable to care for Abby?
It does not.
Have you received all of your custodial time with Abby?
No, I have not. I have not. Sorry, may I continue or should I wait?
Just wait. You have not. Okay. So when did you stop receiving your custodial time with Abby?
The first day that I was supposed to pick her up and did not receive her was September 25th. It was a Friday.
Okay. And your normal exchange time would have been 3 p.m., correct?
Correct. And that is just about the time I showed up.
Okay. And what happened when you tried to show up or tried to pick up Abby?
Well, I had spent, when I showed up, I was told that Abby was not going with me.
Who told you that?
The 25th was the Friday. That would be Mike. Mike and Abby were both home as Mike is off on Fridays.
Okay. Did he tell you why?
He said that Abby no longer felt safe in my home, and since I was leaving for a weekend in California wedding, that she would be more comfortable at his house working on homework.
And how did you respond?
I told him that it is my weekend, and if she is not going with me to California, as she said she wanted to on several occasions, that she would stay with my parents, my father and my stepmom, and she refused. Michael told me that it was not my right to designate who she stayed with.
Why did you think it was your right?
Because it is my designated time per the joint custody issue, and where she goes is up to me because it's my time. There's no right of refusal. There's no, if I'm going to leave town, I have to give her to Mike first. If I'm going to leave town and she doesn't want to go with me, I can choose who she stays with. Same as he did when he went hunting and left her with her friend for 2 days.
When was that, if you recall?
It was the weekend before school started. She stayed with her friend both Saturday and Sunday, and school started on Monday.
And did he notify you prior to that hunting trip?
He did not, Abby told me.
Okay. And when did she tell you?
When she was with me on my days prior to that weekend, she said she was going to be spending the weekend with her friend. And when I asked why, she told me her dad was going hunting.
So what was the end result on Friday, the September 25th? Did you get Abby? Did you not get Abby?
I did not get Abby, and I believe that was the first time that Michael called the police on me. And I had also called the police, not knowing he had called the police, because I knew that it was my day, and he had already told me that she wasn't going with me. So when I got there and they told me that she wasn't going with me, I said, it's my day, you need to send her with me. He said, I will not manhandle her into the car. I said, you don't need to manhandle her. You're a parent, just tell her how to do it, and she should do it. He said that he'd called the police. I said I had to. This is all via text. He would not speak to me. He would not come out of the security gate. One of the texts actually said that him and Abby were in the backyard, and I could come talk to them through that gate if I'd like to. I did not. I waited 2 entire hours from 3 till 5 for the police to show up. The police sergeant called me, said there had been a giant fatality at Rancho and Craig and that they would not be coming unless I waited more hours. And he could not give me an ETA, estimated time of arrival. And he also said there was nothing he could do for me.
Why did you decide not to go to the backyard gate?
I actually didn't see that text right away. It was part of a longer text, and I obviously didn't read the whole thing. However, once I saw they were in the backyard, because I was with my father in his truck, since she was going to go to his house, my dad said they're in the backyard, and I looked over and saw them in the backyard, and that is when I saw the text. But at that point, we had already exchanged. We'd called the police, and she wasn't coming with me, and I believe Abby had even told me to get out at that point. I believe she had texted me and told me she was pissing her off or something like that, and that I should leave.
Okay, but none of this was verbal. This was all via text.
Correct. It's all via text.
Okay. So when you realized the police were not coming, what did you do then?
I texted Mike that the police were not coming. There was a fatality, that I was going to not pick her up today, and that I would be back on Sunday to pick her up after I got back from California.
Okay, so that was your scheduled weekend, correct?
Correct.
Okay. Did you attempt to pick up Abby on Sunday the 27th?
Yes, I did.
Okay. And what happened on the 27th?
I specifically, no, I don't remember every word for word, but again, I was told no, that she was no longer safe and comfortable in my home, that she would prefer to stay with Mike. And when I asked why she was not safe and comfortable, nobody could tell me why.
Court's indulgence for a moment, please.
May I look through exhibits or no?
Hold on, Jessica. Okay.
Okay.
So, as part of your motion for an order to show cause, you filed an amended affidavit in support of that, correct?
Correct, yes.
Okay. So I'm going to have you look at that exhibit. It is Exhibit 43.
Okay. Got it.
Okay. You want to you have two options. You can either review this to refresh your recollection and then testify, or if you prefer, you can read it into the record.
I'm happy to read it into the record as they were my words from the beginning. Would I start from it is further ordered, or would I jump down to the September 28th date?
Let's let Mr. Schneider get there. I see he's trying to get there.
Okay.
Thank you, Audrey. Okay, Audrey, I'm there. If you're going to have your client review it, we can do it at the same time.
Okay, so in order to save time, it is a document filed with the court. So unless Mr. Schneider has any objection, and I can't imagine that he would, why don't we start on page... page 6 of Exhibit 43, number 20, that would be line 7. Mr. Schneider, are you there?
Audrey, give me just a second, okay? We're all over the place. Thank
No
you.
problem.
May I grab a tissue?
Yes.
Oh. Pardon. Everybody's ready?
And Mr. Schneider, if you have a PDF, I can give you the PDF page number. If you have it all in one document, I have that as well to make it easier.
Audrey, I'm sorry. There's, I think, 1,100 pages. So
Right.
now I've got it. I've got it up now. Go ahead.
Yeah, it's page 294 in the PDF. Does that help?
Immensely. Thank you.
No problem. Okay, so I am going to have her start with item number 20 on line number 7.
That on September 25th, 2020, I attempted to pick up our daughter from Mike's residence, but Mike told me that he would not force or coerce Abby into my vehicle. Mike also told me that he was going to honor Abby's wishes, even though the order does not allow for teenage discretion on pages 4 and 5, lines 20 through 7. That on September 27th, 2020, I attempted to pick up our daughter from Mike's residence, but Mike did not have Abby leave his residence, which violates the order filed on October 23rd, pages 4 and 5, lines 20 through 7. That on September 28th, which I believe is the Monday, I'm referencing a blank calendar here, Monday following that Sunday, I attempted to pick up our daughter from Mike's residence, but Mike was not home. He did not require Abby to come with me, which violates the order filed on October 23rd, pages 4 and 5, lines 20 through 7. That Mike's mother opened the front door. See, I was wrong. I apologize. It wasn't Mike. It was Diana. Mike's mother opened the front door, but then slammed it on me. When I opened the door to the inside of the garage to our home, our daughter screamed at me to leave. I left without incident, but I was accused of verbally assaulting and terrorizing our daughter and Mike's mother, and Mike unlawfully trespassed me from returning to Mike's residence, which I still have every legal right as we are legally married. There was no order giving Mike exclusive possession of the same, and I am still on the title and the mortgage for the residence. That I believe that Mike is failing to encourage and foster a relationship between Abby and me. That I believe Mike is engaging in pathogenic parenting and undermining my relationship with Abby. That I believe Abby is triangulated and feels a very strong loyalty to her father, which in turn makes her feel like she is betraying him if she has a relationship with me, wants to spend time with me, or talks about me in a positive light, or enjoys spending time with me.
Your Honor,
That I believe my
Your Honor,
relationship with
hold on one
Abby.
second, please. Your Honor, she's reading from these documents, and she can't read from them. She has to testify. Can't read these documents in open court, Judge.
The objection sustained.
Judge, there is an exception. Recorded recollection, a memorandum or record concerning a matter about which a witness once had knowledge but now has insufficient recollection to enable the witness to testify fully and accurately, shown to have been made or adopted by the witness when the matter was fresh in the witness's memory and to reflect that knowledge correctly. If admitted, the memorandum or record may be read into evidence, but not itself be received as an exhibit unless offered by the adverse party. If Mr. Schneider is willing to stipulate to the admission of this exhibit, then I will not need to have my client read it.
Any objection to the admission of this document as an exhibit?
No, Your Honor, the court can give it the weight that the court wishes to give to it, but my objection has been sustained. So.
Right.
No, I'll.
Right, it hasn't been admitted, so I recognize it is part of the court record, so the preference of the court would be to receive testimony.
Okay, so Jessica, if you need to refer to it to refresh your recollection, you can do so, but let's get more specific. Okay, so the last date we talked about was the 28th, correct?
Correct.
Okay. Did you attempt to pick up Abby on Tuesday the 29th?
I did not.
Okay, why not?
Because the 28th and the 27th and the 25th made it very clear that Abby was not going to go with me. And I felt like Abby and I both needed a break from that stress. It is very stressful to drive there 30 minutes and be told no and then have that in my face and then have to drive home. So, and Abby clearly told me that she doesn't like it either.
Okay.
And I understand that. However, I'm not just going to give up on trying to pick up my daughter.
And when was your next scheduled custodial day after Tuesday, September 29th?
It would have been the following Monday, and if I may reference the calendar, I can do that.
Yes.
And okay.
It's a blank calendar, right?
Yes, correct. It's a blank, dog's messed up calendar.
Okay.
So the 28th was a Monday, the 29th was a Tuesday. The following Monday would have been October 5th.
And did you attempt to pick Abby up on October 5th?
Yes, I believe so.
Okay. And what happened?
I'm sorry, I would like to apologize. I tried 14 different times to pick up my daughter, so the different times do get confusing for me. If I could look at text or another something that would help me to tell me exactly what happened that day if you're looking for specific.
That's unresponsive. She's narrating.
Sustained.
Understood. I did not receive my daughter that day, Audrey.
Okay. Did you attempt to pick up Abby on October 6th, which was Tuesday?
Yes, I believe I did.
Were you able to pick her up?
No, I was not.
Okay, so your next scheduled weekend would have began Friday, October 9th, correct?
That's.
Okay, did you attempt to pick up Abby on October 9th?
I did.
And
I
were
did
you
not
able-
receive her. I was told that she did not wish to join me and Mike would not force her.
I'll object to the hearsay, Your Honor.
Sustained.
Did you try and pick her up on Saturday the 10th?
I assume so. I don't understand why I'm not allowed to look at something. The law, it's 2 months worth of pickups. I should be able to reference something.
Okay, hold on, Jessica.
I'm sorry. Just gonna grab another tissue.
Okay, Jessica, I'm going to have you look at plaintiff's proposed exhibit 41. page 004. Mr. Schneider, that is PDF page 260. You can review that document.